Hey Spartans, welcome back. If you're here, we're going to be continuing our little trip down Deposition Lane with some Mega Man 2. And we're going to be following a little handy guide again from Hand Drawn Gaming. I am not sponsored, but I do recommend. This is one issue. This was issue number 4 that he did. That Phil did, and inside he did all the different Mega Man games, kind of showed off the different orders of fighting the bosses. So I'm going to follow that, and it's not as comprehensive or near as detailed as the one for Mega Man 1, so some of it's going to be us figuring things out a little bit more, but that's okay. Played this back in the day. So yeah, we're going to listen to some more of this testimony and play some Mega Man. So hope you're here, and I hope you enjoy, and I hope you learn something from one side of the screen or the other.
I know this is a document. I know this is a document you're very familiar with, but we'll pass it around.
All right, here we go.
So as the date of your report says, on January 7th of 2025, and as your time as special counsel...
I can't hear Mega Man at all. Like, I thought maybe it was a little bit too loud at times, so I turned down just a touch. We'll go back up just a touch. I don't want it to be real loud because I don't want to drown out Smith's testimony, but you know. Anyway. Okay. Let's try this again.
Counsel was coming to an end. You provided a final report to the Attorney General where you explained the prosecution and declination decision that you made as special counsel as required by 28 CFR 600.8. Is that correct, sir?
That's correct.
What was your goal in preparing this report?
I wanted to, at first, make sure I fulfilled the obligation under the special counsel regulations to do a report consistent with the regulations.
And was this final report an accurate account of your investigation and its findings?
It was.
Based upon your understanding, is it generally the practice for a special counsel's report to be made public to the American people?
I believe so. I know at times they've been, portions have been redacted in the past, but my general understanding is yes.
To the best of your knowledge, do you recall special counsel Mueller's report being made public?
It was public, yes.
To the best of your recollection, do you recall special counsel Herr's report being made public?
Yes.
To the best of your knowledge, do you recall special counsel Weiss's report being made public?
I don't recall. It may be, I don't know.
Was your report made public in full?
This report as to the elections case, I believe it was made public.
Did you have a separate volume or a volume 2 of your report?
That's correct.
Was that made public?
No.
Touching on volume 2, in your letter to the Attorney General,
So the point that the Democrat representative is trying to make right there is that for some reason that we still don't know yet, basically all special counsel reports in the modern era, there's very possible I could be missing something, but the vast majority, if not all, in the last 40 or 50 years have always been put out there, put public. You know, like you said, some things might be redacted, but the report is out there. And the attorneys often take questions in public, at public hearings, just like the public hearings we've had with Special Counsel Herr and Special Counsel Mueller. But Jack Smith is not testifying publicly. Jack Smith's report for the election fraud case, Volume 1 was made public, but not Volume 2. It's still under lock and seal down in Florida because of that stupid Judge Cannon. That's the point he's trying to make with all this right now. Anyway, back to the game and to the testimony.
You also recommended that Volume 2 of this report, which discusses the classified documents case, not be publicly released while the cases of Mr. Walt Nauta and Mr. Carlos de Oliveira remain pending. Do you recall saying that in your letter to the Attorney General?
That's what's in the letter, yes.
Can you explain, please explain why you included that recommendation?
When as special counsel, when you draft a report like this, it's not for me to decide whether it gets made public or not. It's for the Attorney General, and it's for him to also to decide what portions, if any, get redacted in that. And so what I stated was my, in essence, recommendation that it should not be public because these cases are pending and there are facts in here that it might not be fair to have that be public while they have charges pending against them.
Understood. So other than the fact that the cases of Mr. Nauta and Mr. Oliveira were still pending, as you just discussed, did you have any other reasons to believe or to recommend that Volume 2 of the report should not be publicly released?
Well, again, that wasn't my choice. My choice was to write a report for the Attorney General to make a decision about whether it would be public. I have no objection to it being public, and I didn't then, as long as it complies with the law in terms of 6C and other issues like that.
Yeah, but just going back to that recommendation, in making the recommendation in the letter that it not be made public, understanding that it's the AG's decision to release the report, did you have any other reasons for making that recommendation other than the ongoing cases of Mr. Nauta and Mr. Oliveira?
I'm sorry, I misunderstood your question. No reason other than that.
Is there any other reason right now, since Mr. Nauta and Mr. Oliveira's cases are no longer pending, is there any reason now that you can think of, other than Judge Cannon's order, where Volume 2 of the report should not be released?
Judge Cannon's order is the reason.
Excuse me, can I jump in? Do you know who was responsible? Did you dismiss the Nauta and Oliveira cases?
No.
Do you know who dismissed them?
I don't recall, but I imagine it's a matter of public record.
If I told you that it was after Donald Trump was inaugurated, would you agree with that?
I don't recall, but if that may well be true.
For the purpose of this remaining conversation, since that's a publicly identifiable fact, I will represent to you that it was done by the Trump administration. You charged that case, correct?
Correct.
You went through your extensive experience as a prosecutor. Do you believe that Mr. Nauta and Mr. Oliveira were guilty of the crimes that they were charged with?
Yes, we believed that we had proof beyond a reasonable doubt for all the charges and that we would have gotten convictions at trial, yes.
And are you aware of any reason within the rules, protocols, and regulations of the Department of Justice that case should have been dismissed?
In my view, no, it shouldn't have been.
Real quickly, before I turn over to Mr. Jayapal, are you able to speak about Volume 2 today?
I'm not.
Can you explain what you can and cannot speak about with respect to Volume 2?
Well, there is an order of Judge Cannon, an injunction regarding Volume 2. I want to make very clear that I do not want to do anything to violate that injunction or that order. And so, given that I have not seen or looked at Volume 2 since I submitted it to the Attorney General almost a year ago, I do not have a exact recollection of what is in there and not. And so, unless something is in a public filing, or and people can point me to a public filing, or in I think the category that was mentioned in the letter that we got this morning of publicly, I can't remember the terminology, but properly publicly released information. I do not want to, I want to be clear, I do not want to violate that order, and I don't want to do anything that could even be remotely construed as violating that order.
Wait, so, I'm sorry, but DOJ did not let you review Volume 2 of your report?
It may well have been there, but I chose not to review it because I didn't want any implication whatsoever that I was somehow violating the order by looking at it, not being a member of the department now.
So, before we go to Ms. Jayapal, I just want to clear up two things. One,
I'm sure that at some point the Republicans are going to say, oh, he's perjured himself or he said something that wasn't supposed to be there. But I mean, look how professional the guy's being. He is, in light of all the shenanigans that have gone on, he's just a consummate professional. You got to admire that a little bit.
so you've been an assistant DA, you've been a federal prosecutor, you were an international criminal court prosecutor, you were the chief of the public integrity section at DOJ, and you were first assistant U.S. attorney in Nashville and the acting U.S. attorney. Do you have any idea how many cases you've actually handled and prosecuted?
That I've handled or supervised others handling,
Yeah.
I'm sure it's in the thousands.
In the thousands, okay. Have you ever been prosecuted for selective prosecution, vindictive prosecution, or partisan discrimination?
Never.
Have you ever fired a prosecutor because they refused to engage in a prosecution on grounds that there was not sufficient evidence?
No.
Okay. And in all of the cases that you have supervised and prosecuted yourself directly, relating to domestic violence, relating to conspiracy, relating to murder, relating to war crimes, have you encountered the problem of witness intimidation?
Very much so.
Will you speak a bit about the problem of witness intimidation and what that does to the rule of law and justice?
Witness intimidation is probably the most corrosive thing that can happen to the rule of law. And that is why, as a young prosecutor, you are taught to move your cases expeditiously, because you know that if there is someone trying to obstruct your case, the longer they have to do that, the more they can subvert justice. And I've worked on a number of cases. I've worked on murder cases where witnesses were murdered. I've worked on cases overseas involving very serious witness intimidation and obstruction of justice, and as I mentioned earlier, this case as well. And so that was foremost in my mind as we were conducting these investigations, but it's something I've encountered in different contexts throughout my career, even back to those domestic violence cases that I started in earlier in my career. Attempts to threaten or influence those witnesses are a way to subvert justice.
So what kinds of actions and precautions can you take as a prosecutor to prevent it and to try to protect witnesses against intimidation and violence?
So depending on the situation, there would be different sorts of steps that you could take. Obviously, if it's an imminent threat, like someone's coming to kill the witness today, you try to move them and protect them for a period of time. But if it's a more pervasive threat, where a defendant or people on his behalf are issuing statements and issuing threats, trying to get people not to cooperate with your case, or trying to make an example of people who have cooperated with your case, the best thing you can do is limit their ability to make those threats and shorten the time they have to make those threats.
Let me go to Ms. Jackson.
Can I just, one thing on volume 2 before we go? It's obviously a case related to classified documents. Without getting into the detail, how was it constructed? How was it written? Was there an unclassified portion and a classified portion, or is the classified material interwoven in the volume?
I don't think I should even talk about that. I don't want to have any implication that I gave some sort of insight about how that report is constructed, and so I don't really think I could speak about that given her order.
Can I ask you this question? Is it possible to release parts of that report while also protecting classified material?
I very much want to answer your question, but I don't want to say anything that will imply what is in the report, and so unfortunately I don't think I can answer.
Okay, Dan, I'm going to go to Ms. Jayapal. We'll come back to you. Yeah.
Thank you. Mr. Smith, I want to get to questions of transparency again, but I want to pull out to a bigger question. Do you think that it's important for our democracy to hold free and fair elections without interference or obstruction?
Yes.
And theoretically, what happens if there is election interference and the people who are responsible for that are not held accountable?
It becomes the new norm, and that becomes how we conduct elections.
And so the toll on our democracy, if you had to describe that, what would that be?
Catastrophic.
You stated in your testimony in the first hour that you've tried to be as transparent as possible with the American people about your investigation. The chairman of the committee has repeatedly put out that you were subpoenaed for your testimony today, and in fact you are here under a subpoena. But you have requested to appear voluntarily in a public hearing. Is that correct?
Yes.
And why were you willing to appear voluntarily in a public hearing?
We conducted our investigation in a way that I'm proud of. I'm particularly proud of the people I conducted the investigation with, and I wanted to speak for them.
And is it generally the practice of special counsels to appear in a public hearing? I know you have a couple of questions on this, but I want to reiterate this.
That is my general understanding, yes.
And can you tell us again why I understand you want to stick up for the prosecutors, the people that were part of the investigation. Can you tell us why it's important for the American people to hear directly from you about your investigation, what you discovered, the process that you went through?
Well, as I said in the beginning of, I think, in my opening remarks, there have been mischaracterizations about my work. We did our work in the best traditions of the department, and I know I keep coming back to this, but the mischaracterizations that most offend me are not just prosecutors, but career FBI agents, support staff in the department. These are people who devoted their lives to public servants, to being public servants. They have not, they're not self-promoters. They're not people who like to go in front of the cameras and defend themselves. And I feel that they have been vilified in a way that I think is awful.
What's the effect of that on our democracy?
Well, I think it drives people away from public service.
Yeah. Is it a form of witness intimidation?
I think it's even deeper than that. I think, you know, when we get to attacking the people who are the good guys,
yeah.
I just don't know where that goes. It's counter to how I was raised.
Mm-hmm. And let me ask you, even after this deposition today, are you still willing to appear at a public hearing before this committee and speak directly to the American people about your investigation?
Yes.
Can I jump in really quickly just on the witness intimidation issue?
Even after this hearing today, are you still willing to sit for a public hearing and take questions publicly? Yes. That's not someone who's trying to hide something. That's someone who wants to talk. He's willing to take questions from anybody. That's transparency. That's being upfront. Not having a meeting behind closed doors where no one can see it until afterwards, and only putting the video out on New Year's Eve, late at night. Republicans say they're transparent, my ass.
I understand that you were asked a lot of questions about filings that your office made as it relates to trying to protect witnesses, specifically the gag orders. Do you have any regrets about the steps that you took as it relates to seeking gag orders against this defendant in an effort to protect witnesses?
Our applications for orders limiting Donald Trump's ability to intimidate witnesses, intimidate court staff, intimidate my staff, I have no regrets about that.
Dovetailing on that, have you only been further convicted in the decisions that you decided to make as it relates to that in watching some of the president's actions even in present day?
I think the record of our case speaks for itself on these issues.
Could I just follow up on the gag orders relative to the defendants? In every case, a judge decided that that was warranted, correct?
In the cases in the District of Columbia, a judge
Correct.
did decide that, and the Court of Appeals agreed. They narrowed the order, as I said earlier. In Florida, we applied for an order because of statements Donald Trump had made that I viewed endangered FBI agents. That hadn't been decided when the case was dismissed.
Thank you.
And just to kind of finish up on this point, you yourself, I'm not sure if this was discussed by the majority, but have you yourself been intimidated as a result of the actions that you took in this case?
I'm not going to be intimidated.
Have you been threatened?
Yes.
Have you learned of other persons, whether they worked under you as attorneys or other support staff? Are you aware of any threats that have been made against any of them?
Yes.
And, okay, I'll stop there.
Mr. Magoo?
Thank you, Mr. Smith. I really have two questions. First question, which our counsel ably covered, just so we're clear, you wanted to testify publicly today, correct?
Yes, I was willing to.
And Chairman Jordan declined that opportunity, correct?
Yes.
Any thoughts as to why Chairman Jordan is scared to have you testify in public?
I'm not going to characterize the chairman's decision. I offered, he decided that we would do it in this setting, and that is what it is.
Well, I think Americans who review this transcript, once it's concluded, will understand why. If you have any questions.
Consummate professional.
Marcus, let's come back to you.
Okay. Thank you, sir. I'm going to switch gears a little bit to your appointment as special counsel. Do you recall when you were appointed as special counsel?
Yes, it was November, I believe, November of 2022.
Does November 18th of 2022 sound right?
That sounds about right.
Do you recall the day that Donald Trump announced his candidacy for the 2024 election?
I believe it was shortly before that.
So who offered you the position of special counsel?
The Attorney General.
And what was your understanding of why the Attorney General felt it was necessary to appoint a special counsel in this circumstance?
I believe the Attorney General made a public statement about why, and that public statement is my understanding.
We can maybe enter that public statement in a little later. But what did you understand the scope of your investigation to be specifically when you were appointed?
The scope was defined by the appointment order, which encompassed the two investigations that I've referred to today.
And can you just make the record clear again, just briefly describe those two investigations and then appointment order?
Sure, and I don't have the order in front of me, so just generally.
Actually, so we'll make that an
Yeah.
exhibit. We'll make it an exhibit. Let's make the appointment order an exhibit. And this will be exhibit 11, I believe. Make it easier just to refresh your
Sure,
recollection.
thank you.
So after you've taken a minute to review it, and please take your time, the question will be, what did you understand the scope of your investigation to be?
Okay, so consistent with this order, the scope was two investigations, both of them ongoing at the time. The first was an ongoing investigation into whether any person or entity violated the law in connection with efforts to interfere with the lawful transfer of power following the 2020 presidential election or the certification of the Electoral College vote held on or about January 6, 2021, as well as any matters that arose or might directly arise from this investigation.
Do you know why, or have you heard why the Attorney General chose you to be the special counsel?
Why he chose me?
Yes.
No.
Okay. At the time of your appointment, I understand you were living in the Netherlands. Is that correct?
That's correct.
Did you lobby for this position?
No,
Did you petition the Attorney General to be the special counsel?
I did not.
Did you reach out to any former colleagues of the Department of Justice expressing your interest in being the special counsel?
I had been in contact with a former colleague by the name of Marshall Miller. He had returned to the department sometime that summer, and I had spoken to him and expressed to him an interest in, if there was the right position, returning to the department.
Ultimately, why did you accept the special counsel position?
Because I thought I was the right person for the job. I knew that this would be a challenging job. I knew it would be a job where whoever held the job, or whatever decision they made, somebody would want to attack them for that decision. And I felt that given my nearly 30 years as a prosecutor, it made me uniquely qualified to do the work.
Indeed.
Did you have any reservations about accepting the special counsel position?
No.
Nope.
There were a lot of attacks on you shortly after you were named and throughout the time as special counsel. You said earlier, I think you used the term intimidated. I guess, how did you move forward consistently with those attacks while special counsel?
I think attacks and praise are noise, and as a prosecutor, I've learned to tune those things out. I'm more concerned, again, about the attacks on my staff. But for myself, I understand that that's can be part of the work at times.
Did you accept the role, as some have suggested, because you had animus towards President Trump?
No.
We'll try, middleman.
Did you accept the role, as some have suggested, because you hope to influence the 2024 presidential election in favor of the Democratic nominee?
No.
Did you accept the role because you thought it would help the Democratic nominee by prosecuting Donald Trump before the election took place in 2024?
No.
Let's consider the same facts related to the attack on the Capitol on January 6th or the mishandling of classified documents. So that's the facts that we're going to consider here. Take the same facts but insert a president who was a Democrat. Would you have still accepted the role of special counsel?
100%.
Considering the same facts, so the same fact pattern of the attack on the Capitol on January 6th, the same facts of unlawfully taking classified documents after leaving the White House, would you still have accepted the role of special counsel to investigate former President Barack Obama?
Yes.
Again, considering the same facts, would you have accepted the role of special counsel to investigate former President Joe Biden?
Yes.
He seems annoyed at this point.
Looking back, and you've talked about the investigation steps that you've taken here in the deposition today. I think I've heard you talk about, process of an investigation and how that's important. Would your investigative process have differed if the President of the United States would have been a Democrat?
No.
Someone have a follow-up on that?
Yeah. I served on the January 6th Select Committee, and we spent a lot of time looking through the criminal statutes that may have been implicated in the attack on the peaceful transfer of power, the attempt to overthrow the election, and then the violent assault on the Capitol. And we, in our conclusions, cited a number of statutes which ended up, I think, being part of your investigation, including conspiracy to obstruct a federal proceeding, conspiracy to defraud the United States, false statements, and so on. But you added something which I think was very interesting, which was a conspiracy to violate voting rights, which is something that we hadn't done. And I wonder if you would take a moment to expound on why you thought you had sufficient evidence to prove beyond a reasonable doubt that there was a conspiracy to violate the voting rights of the people.
Sure. The right to vote in a presidential election is one of the most sacred rights that Americans have. And in this particular case, we had strong evidence that the defendants in this case sought to interfere with, obstruct, injure that right. We had evidence, in just a couple examples, where President Trump was asking local officials to find 11,000 votes. When you find 11,000 votes, you're diluting other people's votes. We had evidence that they were targeting certain states, and particularly certain parts of certain states, generally urban parts of states, to have those votes thrown out with no factual basis whatsoever. I believe we cited this in our final report, but there's even statements of the co-conspirators in this case, at least one that's coming to mind now, specifically saying we want to get rid of these votes. We want to subtract them. And diluting the vote count in that way, there's strong precedent for that being a violation of the statute that we charge.
There were 60 federal or state court decisions rejecting claims of electoral fraud, electoral corruption that had been brought by President Trump or his teammates. To what extent did that figure into your analysis of that problem?
Well, the lawsuits, we made clear in our indictment that there are proper ways to dispute an election, and asking for an audit, which President Trump did, and I believe in only 2 of the states that were in question, that's a way you can do that. Filing lawsuits, completely legal and proper way to do that. But in this case, those lawsuits were part of our proof that put President Trump and his co-conspirators on notice. The suits, the results, and the things that court said in finding those suits without merit were one component of evidence that put him on notice that these allegations were false. Also, there were instances where there were pretextual lawsuits. There was one lawsuit, for example, that was filed in New Mexico minutes before the deadline, so they could say there was a dispute in New Mexico so they could proceed forward with the fake electors ballot. There was another lawsuit in Georgia where one of the co-conspirators explicitly said in an email, we're on notice that the things in this lawsuit aren't accurate, so we shouldn't have the president sign a certification of this lawsuit. And then they played with the language a little and had him sign a certification nonetheless. And so these lawsuits, well, filing a lawsuit absolutely clearly is something you can do. They were probative evidence of the criminal intent in this case for those limited reasons I just suggested.
Can I go back to volume 2 just for a second? You said that the department gave you access to volume 2 and you chose not to use it?
That's correct. I believe so. I did not, given the injunction, want to look at that. And so I believe it was there, but I was looking at other things. I didn't look at that.
Did they give you access to any classified information that was a part of your files?
No.
Did you or your attorneys have any discussions with the department about that?
I don't recall.
Do you still have your security clearance?
No.
When and how was that taken away?
I think in the normal course of things, when you leave government service, you sign papers basically saying you don't have your security clearance anymore. It's vague, but that's my recollection of what happened at my conclusion of my service.
Do you know if your attorneys requested for you to have temporary security clearance so you could review your own files?
I don't believe we did.
And because you didn't look at the volume 2 that they provided to you, you don't know whether or not classified material was provided to you in that volume?
Again, I don't want to speak about anything that could infer the content of volume 2.
When you provided volume 2 to the Attorney General, did you provide proposed redactions?
I believe we did, but I believe we did.
And the redactions
But
were...
I just want to be, I'm sorry to interrupt you, sir. With the understanding that it was ultimately the Attorney General's decision whether to make it public, whether to do redactions, things of that nature.
And what were the nature of your proposed redactions?
I don't recall as I sit here now.
Was it related to the classified information?
I don't recall. It could have been 6E, it could have been things of that nature.
Did you make proposed redactions because of your concern at all about the ongoing case against Noda and Olivera?
I don't recall that, but I can't be conclusive. I really don't have a good memory of the subject.
Thank you.
I'm curious, shifting gears just a little bit. When you first sat down, the majority was asking you questions that seemingly were tied into the general duties of a prosecutor. And your resume has been laid out. It is interesting, or at least it was interesting to me to hear the majority characterize who should be prosecuted under the current circumstances. I'm not sure if you've followed along, but are you aware that under this DOJ, they have indicted Tish James as well as they ultimately indicted James Comey? Are you aware of that?
I am.
And are you also aware of the fact that this DOJ has consistently dismissed members of the DOJ for refusing to bring forth indictments that they don't believe have merit?
Yes.
The majority was asking you about why it is that you characterize your belief that there was guilt as it relates to the indictment that you sought. As a trained prosecutor, typically, are you supposed to go after people that you don't believe are actually guilty?
I'm trying to. There's a couple of negatives in that question.
I know.
Yeah.
They were trying
You're
to.
not supposed to go after people who you believe are not guilty.
Okay, thank you. In your experience of 3 decades, have you ever needed to seek the same indictment 3 times while being rejected?
Never.
Okay, I think that's all I got for that.
Have you ever prosecuted someone that you did not believe was guilty beyond a reasonable doubt?
Never.
As we hit, I know we're getting close to the end of our time. I want to hit on a few questions. And I apologize if they come off as very obvious to you with your experience and the way that you conducted yourself with the Department of Justice. Did Attorney General Garland or other DOJ officials direct investigative steps within your office of the special counsel?
No.
Did Attorney General Garland or other DOJ officials direct litigation decisions within your office?
No.
Did you experience Attorney General Garland or other DOJ officials interfering with your ability to conduct this investigation?
No.
Did President Biden ever give you any instructions about what you should or should not do related to these investigations?
No.
Did you ever speak to President Biden about these investigations?
No.
I think Mr. Moskowitz has a question.
Thank you, Ranking Member. You know the definition of retribution? Webster's definition. It's a noun.
Off the top of my head, I do not.
If I proffered that it was exacting a punishment against someone, would that sound better?
Yes, and yes.
Your lawyers lost their security clearance, is that correct?
Yes,
People who worked under you were fired, is that correct?
that's correct.
You're here today on a deposition that Sherman has brought you into, and wouldn't give you a public hearing, is that correct?
Yes.
Did you see the comments by the President's Chief of Staff talking about retribution?
I did.
So, everyone was fired. You're here on a deposition. Your lawyers lost their security clearance. It seems like it meets not only the definition in Webster, it seems like this is exactly what Trump's Chief of Staff was talking about. No?
I have no doubt that the president wants to seek retribution against me. I have no doubt that that's the intent.
I don't want to put you off. In
Yeah.
fact, the exact quote was, he doesn't wake up thinking about it, but when there's an opportunity, he goes for it. I mean, this seems like a opportunity. Do you think the White House gave instructions to Chairman Jordan to set this deposition?
So I am eyes wide open that this president will seek retribution against me if he can. I know that. I don't, frankly, connect that with this hearing. I don't have any connection. I came here, I was asked to
No,
come
you
here.
think there were 0 conversations between the White House and Chairman Jordan?
I don't know, but I'm here in good faith, and I was asked to come testify. I
What's the
offered-
likelihood that there were less than 0 conversations between the White House and Chairman Jordan?
I'm not going to speculate on that. I will say I agree that this department wants to seek retribution against anybody who worked on cases against President Trump. I just don't have any evidence
Why do you think
that
the Chairman wouldn't give you a public
That's not for me to say.
I want to go back to your testifying that in every case you've ever brought, you've believed that there is proof beyond a reasonable doubt to demonstrate that the defendant is guilty. I'm not sure it would be even ethical to bring a case if you didn't have that belief. But is there anything inconsistent about having that belief that you can sustain the prosecutor's burden of showing beyond a reasonable doubt all of the elements of the crime are satisfied, and also wanting to see that constitutional due process is observed in the trial? Is there any conflict between those two?
I don't see one.
In other words, as a prosecutor, you go in with the belief that you can make your case, but you also want to make that case within the rule of law and within due process. And you've never experienced that as a problem, right? You've never wanted to trample the rules of due process in order to convict someone.
That's correct.
Okay. Mark, back to you. Over.
I just wanted to piggyback on something that Ms. Crockett brought up earlier, but are you familiar with Justice Manual 927-220?
Oh, I screwed that one, didn't I?
You're going to have to give me more than the number.
All right. So that provision basically states the condition with which a prosecutor can commence or recommend federal prosecution. And I can quote from that section for you. It says, prosecutor may commence or recommend federal prosecution only if he or she believes that the person will more likely than not be found guilty beyond a reasonable doubt by an unbiased trier of fact, and that the conviction will be upheld on appeal. So does that sound familiar to you?
Yes.
Okay. Did you follow this provision when you indicted President Trump in the election interference case?
Yes.
And did you follow that provision when you indicted President Trump and his co-conspirators? Oh, sorry, no, just President Trump in the classified documents case?
Yes.
And his co-conspirators? Did you
In
follow
that case, yes.
Okay. And the majority in their hour questioned you about why you included conduct that has not been found, that has not been brought forth before a trier of fact, right? That has not been proven in a court of law. But aren't you just essentially restating the standard that was that's stated in Justice Manual 927-220?
Yes. With our report, I wanted to explain my prosecutorial decisions, why we made them, the basis for them, and that's why we wrote the report the way we did.
Thank you.
In the last few minutes of our hour, please bear with me as I go through these next questions. There's a lot of inferences and accusations being made about your bias as a special counsel's office, and I want to make sure that we rebut these in the first hour. I think it's important to. So, did the Attorney General or any other DOJ official ever press you to be more aggressive in your investigation of President Donald J. Trump?
No.
Did the Attorney General or any other DOJ official ever suggest that you were expected to bring charges against President Trump?
No.
Did anyone from the White House, including President Biden, ever tell you they expected you to bring charges against Donald Trump?
No.
Come on.
When you eventually did bring charges against Donald Trump, how did you make that decision? Walk us through it at a high level, if you don't mind.
Sure. It was based on the facts and based on the law. I ultimately made that decision, but I consulted with my team of prosecutors on that case, who were outstanding public servants, people with great experience in complex investigations. I took their advice and counsel in making that decision, and I tried to consider all factors, including both the strength of the case that we believed we had, possible defenses, all things of that nature.
So, which based on what you just said, it sounds like you made this prosecution decision based on the evidence in the law. Is that correct?
That's correct.
What would you have done if you felt any improper pressure from a DOJ official or the White House?
I think people who know me and have known my reputation would know that that would not end well. If someone tried to pressure me to move a case in one direction or the other or wasn't supported by the law, I wouldn't stand for it. And I would also say the people who worked in my office wouldn't stand for that either.
Yep, we're at our hour, so we'll end there. Thank you.
All right. Let's see here. How long are they off the record? So they're at the end.
Mr. Jordan, you're gonna start with.
So there at the end, they were just kind of going through and explaining again how it would be unethical for a prosecutor to bring a case if they didn't think they could make the case beyond reasonable doubt and win on appeal. Because that's just basic prosecuting ethics, code of conduct. You've got these egg hats over here who were trying to make it sound like, oh, well, that was improper. How could you think that or include those ideas in your report? That's on, I mean, it's not even been to trial yet. How could you, don't you think that the courts should make that decision? Mother effer. If he didn't believe it, he shouldn't be up there arguing it. And now we have to sit here and listen to more stupid Republican questions, I'm sure. So here we go. Oh, and Wily's Castle. Wily's Castle will probably be a lot more interesting. So just FYI.
Mr. Smith, who's Marshall Miller?
Marshall Miller was a prosecutor I've worked with.
And well, let me go back to last hour. You said the Democrats, I believe, asked you whether you lobbied for the position. And you said you didn't. But then you followed up and you said you made a call to the Justice Department, someone you knew there. And I think I got the quote right. You said, if there was the right position, I would be interested. What was the right position you were talking about?
If I could take you back.
Okay, for a second, hold on. I know this is supposed to be listening to the deposition, and we're going to get right back to it, but the music is just too good. We gotta listen to this music for a minute. That's like the Mega Man music.
Marshall Miller is the person I was talking about.
Well, that was my next question.
Yeah, I learned that he was returning to the Department of Justice. I was still overseas at this point in my State Department position. I reached out to congratulate him about coming back to the department.
And what position did he have at the department?
He was a senior position in the Deputy Attorney General's office. I'm not sure I'm going to get the exact title right, but it was a senior position in the Deputy Attorney General's
My
office.
understanding, he was Principal Deputy Attorney General, number 3 position.
That could well be.
Okay, so you called him and you told him what?
Well, I initially called him to congratulate him.
So I'm going to take it this line of questioning is trying to imply that he somehow got his position not because of his experience or qualifications, but because he knew someone who got him a job. I'm just going to throw that out there.
On coming back to the department.
Okay.
And at
Which
some
has
point,
zero
I told
bearing on the
him
case.
that if the right position came up, I would be interested in returning to the department.
And what was the right position?
I wasn't specific about it. I just told him if the right thing came up to sort of keep me in mind.
What did you have in mind? Do you want to go back to running the public integrity section?
So,
Do you want to be a line lawyer? What do you want to do?
what I recall is right around then there was a domestic terrorism unit being set up, and I don't know if I shared that with Marshall, but that idea that was being set up, I was interested in things like that, but I didn't have a specific.
When did the call take place?
Well, it wasn't. I'm not going to remember specific conversations. I know shortly after he returned, I reached out to congratulate him on returning to the department. At some point, I don't know if it was then or in a call after that, I said if the right position came up, I would be
And so
interested.
you're saying today, you were no way referencing what many assume might happen, which would be there be a special counsel looking into President Trump. That wasn't on your mind. You weren't anticipating that.
When I told him I'd be interested, no.
Okay. Okay. Let's go back to where we left off in our first hour with the toll records. So you seem to indicate that you felt the burden was on the carrier to comply, and that you felt that was consistent with the statute that applies to the United States Senate. Did you feel like you had a burden at all to tell let the carriers know that we in fact are looking for toll records for numerous
I
United
don't
States
know
senators?
which one's which. Heat?
I'm sorry, sir. Which statute are you talking about?
The statute applies to the Senate where you reference that you think the burden is placed on the carriers to deal with this issue with senators, done by the House, but the senators. In our first hour, you said the burden's on them to, if they're going to let the Senate know that their toll records are going to the government, the burden is on them. And I'm just asking, do you feel like there was any burden on the prosecutor, on you, to tell, to make that public?
To make that public?
Not to make it public, to let the carriers know, we are in fact, make it public to the carriers, we are in fact asking for toll records for United States senators.
Sir, I don't recall discussing that particular statute. I may have. What I meant to communicate was that reading that statute as it existed at the time, reading it now, it's clear to me that the process that was envisioned.
So you didn't know about the statute back when you requested the tolls?
I do not recall discussing this statute. I can't recall if I knew about it then or not.
Okay, there's definitely a burden based on what the Justice Department is now going to do and move forward. There's definitely a burden now, but you didn't think there was any type of burden for you to let the carriers know these numbers we are giving you are numbers for, for United States senators.
As you referenced, the statute has now been changed, and before that change, my understanding is that the statute directed carriers to do this analysis, and in fact envisioned that carriers might get.
So there's no burden on you.
notifications.
No burden on the prosecutor. That's what I'm getting at.
My reading of that statute as it was drafted at that time is there was not.
Okay. And you ran the public integrity section back in your days at Justice Department. Is that right?
Correct.
Did you ever get requests for toll records for this internal analysis that you think was, as Steve said, pretty cursory?
We're still on the stupid phone logs. Gag me with a spoon. This is why we're playing Mega Man.
Did you ever get requests for members of Congress or United States senators, their toll records?
It was some time ago. I'm sure we may have. As I sit here now, I can't remember a specific instance, but I'm not saying.
How long were you head of the public integrity section?
I was the head from May of 2010 until it was either January or February of I believe 2015.
Okay, 5 years, and in that time frame, you don't know if you got, you can't recall, you may have, I think is, I'm gonna be fair to you, that you don't recall any request for the toll records of members of Congress or United States Senate.
Well, I'm saying we may well have, and that may well have happened. I just, as I sit here right now, don't recall a specific instance of that. I'm not denying that happened.
Okay.
Once the department gets the records, what does it do with it? I know the FBI has something they call the Cellular Analysis Survey Team CAST. But do you know what happens with the records once they get them?
The analysis, like how they do the analysis.
Like what do you do with the records?
That would not be in my area of expertise. How the analysis is actually conducted.
And how does that get rolled back into the team?
What do you mean?
The team's work, the prosecutor's work.
Oh gosh.
So you subpoenaed Speaker McCarthy's toll records after he became Speaker, and you sought records from November 2020 through January 8th, 2021. Like,
quick weapon?
What were you looking for with his records? Like, what did you do with the information you obtained?
Okay, so what the relevance of those records, there'd be several examples, but his contacts with either co-conspirators, the president, or conduits of information to the president was relevant to our investigation. And an example I could give you is on January 6th, we had information from Mark Meadows, who was present for a call where Congressman McCarthy was asking for help. He was asking the president to come to his aid while the Capitol was being seized. Getting the exact toll records for when that happened was relevant for our investigation, both to question other witnesses about, so we had an accurate timeline, and also to corroborate that the call happened at approximately the time witnesses said it happened.
But it's pretty significant to subpoena the Speaker of the House's toll records, right?
We followed department policy and we followed all legal requirements in getting those records.
I mean, you know, to get the information you're looking for, nobody disputed the Speaker and the President were having communications on January 6th. So one way you could have gotten that information is you could have asked the Speaker's lawyer to look at his phone records and to give you the information you needed, right?
Well, you say now that nobody's disputing, but my experience in criminal investigations is that people often at trial dispute things that you never thought were going to be in dispute during the investigation. And so when I conduct a criminal investigation, I don't assume there will be no disputes. Having a record that is a hard record about a time, and the timeline of that afternoon was particularly important because that violence started. The president refused to stop it. He endangered the life of his vice president. Then he's getting calls, and not calls from Democrats, not calls from people he doesn't know, calls from people he trusts, calls from people he relies on, and still refuses to come to the aid of the people at the Capitol. That's very important evidence for criminal intent in our case.
Right, but you could have asked Elliot Burke for that information, the Speaker's lawyer. You could have asked Elliot Burke to say, can you get us the Speaker's phone records for this time? And he probably would have said, of course, avoiding a toll record subpoena.
And your question?
Why didn't you do that?
We got these records in a manner that was consistent with the law and consistent with department policy. There was nothing improper about how we got these records.
Same with Representative Perry's phone. I mean, you could have asked Representative Perry's lawyer. I mean, there's no evidence that Representative Perry or Speaker McCarthy was interested in obstructing your work, was there?
I don't have any evidence that Speaker McCarthy was, I don't recall any evidence, I should say, that Speaker McCarthy was interested in obstructing our work.
Okay. So with Representative Perry, you could have contacted his lawyer and you could have said, this is what we're looking for. Can you help us achieve this without seizing his phone?
We met in high school. Our daughter is 10 weeks old, very fresh. We have.
Well, with Congressman Perry, I should point out that the seizure of his phone happened several months before I was ever special counsel. I wasn't
Fair.
involved in that process.
Yeah. Okay.
So the point here is that the Republicans are saying, so you could have just called their lawyer and, said, hey, man, can you get this stuff for us? That way, we can just kind of do it behind the closed doors. Don't have to make anything public. Don't have to ruffle any feathers. Just kind of give us the stuff. You cool with that? And what Jack Smith is saying is, as an investigator, I'm going to use the law and the tools to gather evidence in a lawful manner, not doing things behind closed doors and not trusting the people that I might be investigating to give me evidence to incriminate themselves with. And people trust these guys? I don't get it. I mean, they sound like the shadiest snakes I have heard in a long time. A long time. That man right there, the one testifying, I trust that.
Okay. But in hindsight, would you have counseled taking a different avenue to acquiring a member's phone?
I'm not going to speculate on investigative steps that occurred before I became special counsel.
Okay. When obtaining the toll records of members of Congress or anyone, what is the standard? Must there be some evidence that relates to a criminal prosecution or criminal investigation?
So there has to be a reasonable basis to believe that there will be materially relevant evidence.
Okay. Now, with the chairman of the Judiciary Committee, the subpoena, with Speaker McCarthy, the subpoena, the time frame was November 2020 through January 8th, 2021. With the now chairman of the Judiciary Committee, the time frame went back to January 2020. So it was for a full year where, between January 2020 and December of 2020, nobody, had any telephone calls about these matters. I'm just curious why you went back to January 2020, the office did.
Sorry, I just want to clarify. When you say you went back, can we just get the date of when the
It was May
subpoenas were
1st,
issued?
2022, and it was before you were appointed. When I say you, I apologize. I mean the office, the effort. I mean, this was before you became special counsel. The D.C. matters were headed up by Thomas Wyndham, as I understand it.
I believe that's right.
And the Florida matters were headed up by Jay Bratt.
That's
Okay.
correct.
And so the question is, why would DOJ, why would the team seek records from January 2020, through November of that year, before any of these issues, before anyone knew about any of these issues?
Yeah, I played no role in that subpoena. I was still in Europe at the time. And because I wasn't present or involved, I'm not going to speculate on the basis for the range of time that the prosecutors in that case saw it.
Okay. After you became the special counsel, that information obtained from the subpoena, was available to the special counsel team. What did the team do with it after you became, after you were sworn in?
You mean when you say that information, you're talking about the toll?
The toll record subpoena for the chairman of the committee.
Well, I can tell you that, for example, there were there was contact on, for example, January 6th, that again, another example for you is Mark Meadows. When we interviewed him, he referenced the fact that afternoon, Chairman Jordan had been in contact with the White House, and like Congressman McCarthy's contact with the White House, it was relevant because, and again, Meadows stated this, that these were supporters, these were credible people that the president relied on, and what I recall was,
is this going to work?
Meadows stating that I've never seen Jim Jordan scared of anything. And the fact that we were in this different situation now where people were scared really made it clear that what was going on at the Capitol could not be mistaken for anything than what it was. And it goes back to that sort of information from someone who is a credible source to the president, proving that actually happened and that there's actually a record of that call and exactly when it happened and what actions happened after that or didn't happen after that, extremely probative to our case.
Right, but DOJ took Mr. Jordan's phone records from January 2020 through November, through January of the subsequent. I mean, what on earth could the Justice Department want with his phone records before time's relevant?
Sure, and the breadth of that subpoena was before I was special counsel, and I wasn't involved in the deliberations about seeking that subpoena or the breadth of it, and so
So, let me translate this. Republicans are asking, why would they want to talk? Why would they want to know who anybody was talking to, back in November before January 6th or any of this? I was like, why does that matter? Well, it matters because right after he lost the election, he spent 2 months saying that it was all fraud, it was all lie, and this election had been stolen, and spent the whole time ginning everybody up, trying to figure out a way to stay in office. And you all conspired to help him. That's why it's important. You all, as in the Republicans.
I can't speak to that.
Okay. Can you see from our point of view that there's a perception that there's some overreach going on there?
I understand your question. I don't have any, and I do understand it, I don't have any reason to believe that subpoena was secured for any improper purpose, or that it was secured in contravention of department regulations or the law.
Okay. And in terms of who is involved with the authorizations for that type of subpoena, it's your team, it's public integrity, any other Justice Department component?
I cannot speak to that before I was special counsel. I can say that when I was special counsel, I was the person who approved subpoenas of that nature.
Okay.
And with, of course, the fact that I wanted consultation with public integrity.
Okay. So that was the universe of DOJ authorization. It was you and public integrity. You didn't have to go to the DAG. You didn't have to go to OLC. Correct?
That's correct.
Okay. When the subpoena was served for certain members of the Judiciary Committee, it was served by an official at the Department of Justice's Inspector General, which, from our point of view, raises a conflict of interest. I mean, the Inspector General is supposed to be conducting oversight, if necessary, of department components. Certainly, if department components are being real aggressive with members of Congress, we might want the IG to conduct a probe of that, right? But if the IG's on your team and they're doing this with you, that presents a problem for us. And so the question is, why was the IG's office serving these subpoenas? Why were they, they went in, I know it was before you were the special counsel, but they went on the Perry search. They took his phone and then they imaged his phone. I mean, the IG here is just like a regular part of the team. Can you explain why that happened?
Yes, with the understanding that I obviously wasn't in that decision chain because I wasn't involved in the case, but my understanding is that the Jeffrey Clark component of this investigation, he was a Department of Justice employee during the period of time that we were, and my predecessors were investigating this, and it's my understanding that is why they were involved in the investigation.
But, understood, but why, when it comes to members of Congress, didn't, like, I don't understand, like, yeah, I understand they had the Jeffrey Clark investigation going on, but when it comes to members of Congress, I mean, the IG has a special, relationship with Congress. Why are they allowed to be involved?
Again, all I can tell you is what I just told you. This was before my time, but my understanding about why it occurred is because they were involved in that aspect of the investigation.
Okay. And were they involved after you became the special counsel? Were they involved in serving toll record subpoenas related to members of Congress, to your knowledge?
My recollection is that they may still have been involved. My primary dealings were with the FBI, but they may well have stayed as part of the investigation. I didn't have a lot of interaction with them.
Okay. And when some of these toll record subpoenas were served by the IG's office,
see if we can get this tank this time.
Do you know whether they knew they were serving toll record subpoenas related to a member of Congress?
Are you talking about in the period of time when I was special counsel or before?
When you were the special counsel.
Okay. As I sit here, just to be clear, I'm not aware, I don't recollect that people in the DOJ Inspector General's office were serving subpoenas during my time.
Okay.
Could well be. I just don't have recollection of that.
Okay. I can represent to you that they did serve subpoenas before your time. I mean, they served one in May of 2022 relating to the chairman of the committee.
Yeah, and as I said, before my time, I can't speak to that because I was in Europe. I wasn't in the investigation.
But after you became, after you were appointed, that wasn't occurring to the best of your knowledge?
I just don't have a recollection of that.
Okay.
But I want to just to be clear, I'm not sure in my role I would know which individual agent was serving a subpoena, so that's not something I would have necessarily known in the first place. Just I wanted to make that clear.
Fair enough, but if it was from the IG's office, wouldn't that raise like an issue?
I'm just saying to you, in my role, I was not like directing which agent would serve which subpoena.
Okay. Did you have interactions with the IG's office on the Jeff Clark matter?
I can't think of any now, but I don't want to say that they may have been possible I did, but as I sit here now, I can't think of any.
I mean, were they a part of the team after you were appointed?
That's what I said earlier. My recollection is that they were.
Okay. With the toll record subpoenas for the senators, one of the lines requested was a Senate landline. Did you know about that?
I don't recall knowing about any particular lines. My role, as I saw it, was to understand who my prosecutors thought we should be getting toll records for, to make sure we had a basis for that under the statute, a reasonable basis. I don't recall discussions about how they figured out what lines we would be going for.
Because at least in the House, if you place a call from a landline in the House, it goes out scrambled. So, to the extent DOJ thinks they have the right number, it's, it would be scrambled. And so it's just raises questions as to why the office would subpoena toll records for a Senate landline.
All your questions raise questions as to why you're asking stupid questions.
You don't have any additional information or recollections on that?
I really don't.
Okay.
It's like I really...
There was some litigation with AT&T over the subpoenas for the Senate lines. Do you have any recollection of that?
Was it litigation, or I know I saw, or I was shown that there was a letter that from AT&T to Senator Grassley. I don't recall any litigation.
Okay. Maybe litigation was was the wrong word, but AT&T, I guess, pushed back on the toll records subpoena. And according to them, after they pushed back and said they weren't comfortable producing the records, the special counsel's office stood down. Do you have any recollections from that?
I don't have any recollection of that.
Okay. And essentially AT&T represented, at least to Senator Grassley's office, that after they said no, we're not going to give you those records, your office didn't press the matter further, which raises the question why. But your testimony is you don't have any recollection of that.
I don't have any recollection of it. I also don't know from the letter what the reason they gave for not giving it, but I don't have a memory of any of this.
Okay. To the extent members of Congress and senators are up in arms that this happened to them and they're seeking accountability, who should be held accountable for answering these questions?
Well, I think who should be accountable for this is Donald Trump. These records are people, in the case of the senators, Donald Trump directed his co-conspirators to call these people to further delay the proceedings. He chose to do that. If Donald Trump had chosen to call a number of Democratic senators, we would have got toll records for a number of Democratic senators. So responsibility for why these records, why we collected them, that lies with Donald Trump.
Well, I understand that's your perspective, but in terms of there are calls from United States senators to impeach Judge Boasberg because he signed this NDO order. We've asked you questions, for a good bit now about whether your office should have taken additional steps. So it's either your office, the judge, the carrier. In your view, who needs to be held to account on these toll record subpoenas?
Well, I don't. Certainly, my office did everything consistent with the law and department regulations at the time. As I think we referenced earlier this morning, the department regulations on this, since we issued these toll records, has changed. I believe now, and I believe this is in 2024, if we were to make an NDO application to a judge, we would need to identify if they were members of Congress. And so, to the extent you think something needs to be changed, that change happened, but that was not required at the time that we issued these subpoenas.
Okay.
Interesting.
Sort of begs the point, though, doesn't it? Don't you think? Sort of begs the point, like, it makes the point, like, maybe that should have been the standard, it should have been burdened on the prosecution to actually give that information to the carriers. Would you agree?
No, as I said earlier, I think we followed the regulations that they existed at the time. If the regulations that are now in effect were in effect then, we would have followed those regulations.
I just want to circle back for a second. Who first contacted you about taking the position of special counsel?
Marshall Miller.
Same guy you reached out to early on.
Correct.
He said you'd be interested in the right position. So when did he call you?
It was some point, I told you earlier, there was this initial conversation where I said,
that.
Right. Some point after that, he contacted me about ultimately the position that I ended up having.
Okay, and I'm trying to find out when that was, because you called him when he took the job in the summer of 22, which is before President Trump announces he's running for president, before you get appointed by the Attorney General. I want to know when you talked to Mr. Miller the second time, or the third time, or how many times did you talk to him?
Between the time that I originally reached out to Marshall Miller and the time that I was appointed as special counsel, I spoke to Marshall Miller several times.
Several times, okay.
Hey, Jim Comer,
and then he's the one who first
go,
asked you, would you be interested in being special counsel, is that right?
And look the other way some more.
I don't remember how he phrased it, but my recollection, to the extent I have one, it was not phrased in terms of being the special counsel. I think it was in terms of being involved in these investigations.
And again, when was that?
I'm having trouble recollecting. It definitely was after he first reached out to me.
Wait. I thought you called him first.
I'm sorry, you're right.
Okay.
I after I first reached out to him, we had multiple conversations between then and when I was
In the
appointed.
summer of 22, when he takes the position as number 3 guy in Justice Department, and between November 18th, 2022, when you get named, you had multiple discussions, multiple conversations.
Yes, I just also to be clear, not all those conversations were about this position.
I'm not saying you were, it was
Okay.
multiple conversations. Did he ask you to, did he talk about special counsel position, the one you took, prior to the Attorney General asking you to take the job? I thought you said yes to that earlier.
Yeah, what I'm trying to remember is my recollection, and it is a little vague, is that the idea that working on these cases would be in the format of being a special counsel. My recollection, that it's imperfect, is that was very shortly
Okay, so
before
what
I
did you
was
say?
appointed.
Did you talk about Arctic Frost? Did you talk about Plasma Gecko? Did you talk about these investigations, the Florida case, the DC case? What did you talk about?
I don't recall him ever talking about Arctic Frost or Plasma. I don't remember.
Those are some names. Did you talk about the 2 cases?
Yes, at some point it was not clear to me whether, when he first, my recollection again, and it's not perfect, is it wasn't clear to me if it would be working on one case or the other or both. I'm not clear of how that first came up.
Okay. And these conversations were before President Trump announced that he was running for president?
Yes.
Okay. And were they before the midterm elections in 22?
When were the midterm elections?
November. First Tuesday after the first Monday in November.
I think I spoke to him both before that and after that.
Okay. And then how did it go down at the end? Did you tell Mr. Miller, you know what, President Trump's announced, they may be considered, how did it go? Did you just tell Mr. Miller, I'd be interested if there's an official special counsel, how did it go after President Trump announces? How'd that conversation go?
My recollection of this is that I was asked if I would accept the position if it were offered to me, and that was before President Trump announced his candidacy.
When you were sworn in as special counsel when you were in Amsterdam, is that correct?
Yes.
Who swore you in?
I don't recall.
And was it over Zoom or something?
Don't recall.
Or was someone present? Was, Mr. Cooney or Mr. Cooney and Bratt and several folks came to visit you in Amsterdam, is that right?
Not in Amsterdam. I was in The Hague, in the Netherlands. They probably flew into Amsterdam.
Okay.
Yeah. And yes, they came to see me shortly after I was appointed.
But you don't remember who administered the oath? Who can administer the oath? Like, who's authorized at DOJ to administer the oath?
I don't know.
But you did take an oath. You remember that?
I do recall that, yeah.
But you don't remember whether it was was it in the Netherlands?
I was still in the Netherlands is my recollection.
Okay. So it had to be either a DOJ official came to see you, or it had to be over Zoom, right? Those were the options?
Or over the phone. I really don't have a recollection that I can help you here.
Okay. And do you know the total cost of your probe?
I do not.
Rough? Can you give a rough estimate? Or?
Well, the special counsel, our office, consistent with past special counsels, gives a public report of expenditures, and the last, I'm not sure if the last one that we covered, the last however many period of time was ever actually published, and so you'd have to add that into the total. So that's why I say I don't know.
At the time, the last published report, I think it was at 20 million.
Okay, I don't recall that. Whatever is in the public reporting on this would be accurate.
Oh, shoot, I gotta do it on this link again.
The genesis of the alternate electors case started with the National Archives IG. Is that your understanding? They first raised flags that they were receiving alternate electors to the Justice Department.
That I believe would have been well before I was special counsel.
Okay. And when you became special counsel, was that part of your, like, where did the alternate electors case stand, when you became the special counsel in November of 2022?
So the fake elector scheme was part of what I was investigating, and it ultimately became part of the charges in the case.
Okay. But where did it stand as of November 2022?
Where did it stand? I think the people assigned to that investigation were investigating it. Exactly how many interviews they conducted, things of that nature, I can't recall as I sit here right now.
Before you became the special counsel, there was an effort to get DOJ moving on this, and an individual named Amanda Vaughn, a prosecutor on J.P. Cooney's team, indicated that DOJ would not be pursuing the case. Were you aware of that?
Was this when I was special counsel?
This is before you became special counsel.
I don't recall that.
And so the question ultimately is it seems like the alternate electors matter, it seems like it was subject to a lot of starts and stops. And wanted to know whether, after you became the special counsel in November of 2022, were there any starts and stops, or was that a full speed ahead on that probe?
That was a part of the case that we investigated from the time I started until the indictment. It ended up being one of the most powerful parts of the case. We had electors who were going to be witnesses. I referenced earlier a congressman from Pennsylvania who had said this was an attempt to overthrow the government. We had other electors who said, I was told that this would only be used if we won in litigation. And obviously the record in our case showed that the co-conspirators were trying to use their elector votes despite that fact. And again, this goes to the point I made earlier. These are people who wanted to be electors for Donald Trump. They are not people who are opposed to him. They were not people who are from a different political party or enemies. And so the fact that we had elector witnesses like that who felt either they'd been misled or they felt that this whole effort was an attempt to overthrow the government, I thought that was pretty powerful evidence. And so we moved that part of the investigation forward with the rest of the case.
Did your office coordinate with state officials?
You mean interview state officials?
No, coordinate. Several other, state probes cropped up. In Arizona, in Fulton County, Georgia,
crash weapon.
And I'm wondering how you coordinated those efforts.
I know that we got inquiries from state authorities. I'm aware of that. My recollection is that we did not share any evidence with them. And I don't think, my recollection is we did not get any evidence from them. We got it from, that is my recollection, that it was all or largely from public sources.
Okay. Was there somebody on your team who had responsibility for liaisoning with the Attorney General for the state of Arizona, Chris Mays?
There'd be a bit there somewhere.
I don't believe so, but also the liaisoning, I don't think that, my recollection is that there was not like an ongoing discussion. What I was thinking of, I know we got a letter, for example, from the Attorney General in New Mexico asking for information from us. I don't have a specific recollection as well as to other states. It may well be that we got other inquiries.
So there was no proactive coordination?
No.
Okay, there was no proactive coordination, regular communications with Chris Mays' office in Arizona?
I don't recall any regular communications, but I'm hesitating just because I don't recall, as I sit here, how many times they might have reached out to us or that sort of thing.
Right. How about with the Fulton County DA's office with Fonnie Willis and Mr. Wade?
Yeah, I've never had contact with either of those people.
Okay, do you know if anyone on the special counsel team, on your team, had contact with them after you were appointed in November of 2022?
I don't believe so. I will just say, though, that one of the things we were investigating was things that happened in Fulton County. Particularly, there was an election worker by the name of Ruby Freeman, her mother, and she was the mother of a woman named Shay Moss. They were people that Rudy Giuliani and Donald Trump targeted with absolutely false claims of election fraud, claims that Rudy Giuliani later admitted he didn't have evidence for, claims that he was held liable in defamation for, caused them to endure all these sort of vile threats. And that whole episode, as well as sort of the claims, the false claims about the vote count in Fulton County, we did look into that and collect evidence. I don't have a recollection, as I sit here, that we interacted with the Fulton County DA's office for that, but if we did, it would be only for that.
Okay, did you try to deconflict their prosecution from what you were working on?
Well, we didn't. I was not interested in sharing information with them, so I did not give them information. I'm not even sure, testing my recollection now, but I don't even think we got a request for information from them.
Did you have coordination as far as scheduling was concerned?
I don't recall anything like that.
Okay. Because their proceedings were going on concurrently with your DC case, with the Florida case. So you don't remember you or anyone on your team having communications with Fulton County to coordinate scheduling?
No, I was aware, obviously, that their case was pending, but I did not coordinate any scheduling with them.
Okay. How about with the Attorney General for the state of Michigan?
Again, it may be that they requested information from us. As I sit here right now, I should say I don't have a really good recollection of this subject matter you're talking about, but I don't recall us giving them information, and I don't recall getting information from them.
Who on your team would have that information?
Well, Thomas Wyndham and Molly Gaston led that case, and along with J.P. Cooney, that would probably be people who might recall these things with more specificity than I am.
Okay. So if somebody has the information, one of those three people should be able to help.
There may be other people in the office as well. I'm saying them because they were the direct supervisors of the prosecutors on that case, and they may have a better recollection.
Using the crash weapon. Quick. Very quick.
Same question with the District Attorney of New York's office. Did your office have any communications with that office, coordination?
No recollection of that.
Did you have any communications regarding scheduling?
Again, I have no recollection of that. I was aware of their case pending, but I don't recall any coordination with them.
Did your office or anyone at DOJ, your knowledge, try?
This goes back to the Republican conspiracy theory and idea that all these cases that were brought against Trump were all coordinated by Biden, basically, and the Democrats. That all of it was coordinated, and all of it was a way to try and get Trump, because it's not like he did anything wrong. He's just persecuted for, standing in the way for the little guy. It's not like he's a corrupt a-hole who takes things he's not supposed to and tries to steal elections and is fine to let his mob attack anyone, Capitol Police, senators, Republicans, Democrats, anybody, Congress people, as long as he gets his way. It's not like he did anything like that or committed, millions of dollars of tax fraud or, had, how was it put, forcible sexual contact with E. Jean Carroll. No, it was just a conspiracy theory to get him. Yeah, that's all it was.
Try to dissuade the district attorney of New York from bringing that case?
I do not recall that at all. And that I'll just say I have a better memory. I do not remember anything like that.
Were you enthusiastic that the district attorney of New York was bringing that case?
No, I didn't take any position about it.
Okay, because it was going on at the same time that you were trying to move forward your two cases, correct?
Did it get you excited, Jackson?
And
did it make
you
horny?
didn't have a view that the case out of the district attorney of New York's office was going to be a distraction? Litigating whether there's payments to some performer and how that relates to the Trump organization's accounting protocols. I mean, that is very different from the two cases you were pursuing.
Yeah, the two cases are completely different.
And so the question was, do you think that the district attorney of New York's case presented a distraction for what you were trying to accomplish?
A distraction? I don't know that I thought about it that way. I can't recall any discussions along those lines.
I mean, there were a number of times when you wanted to be in court in D.C. and you had to work around the president's schedule because he was in court in Manhattan, correct?
I'm not sure that's right. Maybe that's right. I don't know if there's a record about that. I don't. I shouldn't be asking you questions, but is there? I don't recall.
Yeah, there is.
Okay, so I'm not disputing you then.
I mean, one of the issues is, the president was represented by, he had his team of lawyers. It was pretty small group. They weren't backed by big law, right? So they didn't enjoy a robust, hundreds of, lawyers back at the office to be able to digest some of these things. And so, President Trump's lawyers, were required to be in New York part of the week, and then they had to come to D.C., and then they had to go to Florida.
Why, President Trump's lawyers were just old times, country folk who were out there trying to defend a man who was wrongfully accused. They didn't have any of that big city money, hundreds of people behind him. No, he just a normal man, just like you and me, with millions of dollars. Some say billions. And he just a normal guy, just like you and me, with all him billions. Yeah. I mean, what is wrong with these people? And what is wrong with the people who buy that crap?
And so the question is, did you ever coordinate with the district attorney of New York to...
What am I doing here again?
Maybe not be at trial one day so you could have the president and his lawyers here in D.C.?
Right?
I don't recall that.
Okay. And was any of that a distraction?
It wasn't a distraction from us because, as you said, that case had nothing to do with our case.
Okay. There were a number of times that I believe Jay Bratt took the position that the president ought to go get some more lawyers. Like if Todd Blanche and John Lauro, if they can't handle all these cases, they should just go find different attorneys for President Trump. Were you aware of that statement by Mr. Bratt?
What context was that?
Before the court in D.C. and Florida. Actually, Mr. Bratt was in Florida.
Yeah, I don't think Mr. Bratt appeared in court in D.C.
In Florida, I'm sorry.
If you could direct me to specifically what he said, as I sit here now, I don't
Okay.
recall that, but I'm not denying that happened.
Maybe we'll revisit that, but we can point you to.
Sure.
But you would certainly agree that the president gets to pick who his lawyers are, and if he wants to have Todd Blanche and John Lauro and not others, that that's something that the government ought to be able to work with, correct?
Sure, although, I, not this case, but other cases, I've seen judges say that if you're going to pick lawyers because they're unavailable, that you can't do that. And if
Well, that
you're
wasn't the case here.
Well, if you're picking lawyers because they, that will allow you to sort of delay the case, that's not something that judges usually put up with.
But, President Trump, nobody from Big Law would represent him. Isn't that a pretty well-established case?
I don't know that.
And like Mr. Blanche had to leave his firm to take on the representation?
I know he chose to leave his firm. I don't know the circumstances behind that.
Middleman's put the case middleman out.
Maybe it comes as a surprise to you, but there are really two different Washingtons when it comes to lawyers, and Big Law downtown just does not have a great appetite for hiring former Trump alumni, lawyers that worked in the Trump administration with Republicans generally. Are you aware of that?
I have not worked in Big Law. I've been a public servant my whole career. That's the world I know.
Okay. By contrast, the lawyers on the January 6th committee, they leave the Hill one day and they're immediately gobbled up by Big Law very quickly. That just doesn't happen with Republicans. Would you agree?
That Republicans don't get jobs as lawyers? I'm sorry.
At big law firms.
I don't actually know that that's true. Again, this isn't a world I have worked in, but I think there are Republicans at big law firms.
Okay. Republicans that represented Donald Trump zealously?
I haven't kept track of that, but you'd said Republicans at law firms.
That's not something I've kept track of, but I think there are Republicans at law firms. What are we even asking here? How does this have to do with anything that he did? What is? Oh.
So
we're PO now because it's Jack Smith's fault that Republicans don't get hired at Big Law and they don't get to make the big money. What are we talking about?
I've seen plenty of power banks over my 15 years of reviewing tech, but this Ridge one quickly became a favorite. So this?
When your office filed its proposed DC schedule in August of 2023, were you aware that your office also had a concurrent schedule, operating in the Southern District of Florida? You essentially had two cases going at once.
Correct.
And so how did you deconflict those scheduling appearances?
Well, there were two separate groups of lawyers working on those cases, one on the classified documents case, one on the investigations case.
Was that the case for President Trump?
I'm sorry?
Was that the case for President Trump as well?
I'm trying to recall. I know John Lauro, who I think was the lead counsel in the Washington, D.C. case. I don't believe he had any involvement in the Florida case, and I know Christopher Kais, I think was his name, was in the Florida case and didn't have any involvement here. I don't know. Okay, also, right. I should say, right. I don't know how many lawyers supporting the lawyers in court President Trump had that were supporting one case or the other case.
In February of 2024, your office proposed an April hearing in the Southern District of Florida. At the time, you were aware that President Trump was scheduled for a full-day jury trial proceedings in New York on April 1st, 2nd, and 4th. So your proposal required the president to attend trial in New York on April 1st and 2nd, travel to Florida for a hearing on April 3rd, and returned to New York for trial on April 4th. Do you recall that type of extraordinary logistics the president was put through?
Can you say that back to me? I just didn't, you said some dates in the beginning. If I could just hear it again.
On February 29th, 2024, your office proposed an April 3rd hearing in the Florida case.
Okay.
At the time, President Trump was scheduled for, full-day jury trial in New York on April 1st, 2nd, and 4th. So you pick the 3rd, the one day that he had off from trial. Does that ring any bells as we refresh you about that?
It doesn't ring bells, but I want to be clear. I'm not denying that those dates are accurate.
Do you think that's reasonable in hindsight?
I think our requests to the court were reasonable, yes.
And you think it's reasonable that President Trump had to be in New York on the 1st, 2nd, and 4th, and then travel to Florida on the 3rd?
I think our requests were reasonable, yes.
So just to clarify, what kind of hearing was it? You said a hearing in the Southern District of Florida on April 3rd. Is there any more information about what kind of hearing it was? Was it just a status conference or something different?
As we understand it, President Trump had to be there. I think, if it's a status conference, I'm sure the judge would. We only have about
That's so you can move on.
left, so
I didn't mean to delay things. No, you can keep going.
Steve,
Okay.
Mr. Smith, can I just ask a few questions? When you were hired in November of 22, how did the department educate you about the predications for the investigation? What evidence had been collected?
I got educated on the cases by debriefing with the people who were leading the investigations.
And in terms of when that full autonomy was handed over, how quickly did that happen?
Sure. So I was appointed on November 18th, that Friday. And time difference, right, because I'm in The Hague.
Yep.
I requested that evening that someone get on a plane to come over and debrief me immediately.
Who that was?
It was J.P. Cooney was the first person who came over.
He came alone?
I believe he did, in my recollection right now, and I think he got there, maybe it was till, I can't remember if it was Saturday or Sunday, but he got there Sunday and began giving me a summary of the work.
And was that just digital case files? Was it hard copies?
It was oral.
All oral?
He came over to debrief me orally, yes.
When was the first time you started to look at some of the materials? Only reason I'm asking, DOJ alum, when I got an investigative memo, I would start going through and looking through the materials myself.
I did that.
Yep.
I'm having difficulty remembering exactly when that happened, but I certainly did that. It was early on.
In terms of the way you approach this, did you go through and kind of review the predication for all of the investigative steps that have been taken to that point?
Review the predication for...
So whether it was pen registers, search warrants, did you review all of that, or were you just looking at kind of the summaries of the information, the evidence that had been collected?
I think I was looking at kind of the overall where the investigation was at this point in time.
Okay. In terms of the staff decisions that you made, how soon did you start staffing up your office?
Well, the office was primarily staffed with people who had already been on the investigations. The majority, I think, were people who had already been on the investigations, and so there was a period of time shortly after I appointed where we had to determine, they had to determine if they were going to stay on the investigation.
Did you ultimately make that decision?
Yes.
Okay. So did you go and meet with every one of those individuals?
I was still in The Hague at that point in time, and so J.P. Cooney had those meetings.
In regards to the law enforcement officers, did you have any say in which agents worked for this investigation?
The squads that worked on these investigations were the same squads that were already working on the investigations when I took them over.
Did you amend those, the personnel at all?
The FBI?
Yeah.
I don't recall doing that.
Okay. And then just to follow up on what he said, was there ever any contact between you or any of your team with some of those other prosecutorial offices, whether it be DA, AGs, for the purposes of evidence sharing,
I may have worked a lot.
information sharing?
Yeah, as I said earlier, I don't have a recollection of that.
But was there a policy as the boss of the office? Did you have a policy with that? If someone had done that, would they have had to report it up the chain to you?
Yeah, if someone had said, I want to call Fonnie Willis and have a conversation and get evidence from them, I would expect no one would do that unless I said it was all right.
And in your recollection, that never happened?
I don't have a recollection of that. As I said, I just want to be as clear as I can. I don't have a great recollection of specifics with different attorney general's offices, but my recollection is we did get reached out to by offices. I'm thinking of one letter I do recall. May have been, yeah.
Other officers reached out to you?
Yes.
Okay.
That's what I recall.
Yeah.
And so there may have been interactions as that result. As I sit here, I don't recall asking
You
them.
initiate.
Or asking them for evidence. But again, I think, as I directed, I think the people who are the team leaders on those cases and JP Cooney might have a closer recollection of that.
But your memory is there was no outreach that you had to approve or sign off on?
Outreach that I did sign off on. I don't recall anything like that.
Hello, my name is Alexander Yermak. Until 2022, I was a musician, and now.
Who did the letter come from again? Just refresh my memory. Did you got one letter?
Only one I remember is I remember we got a letter from the Attorney General in, I believe it was New Mexico. That's my recollection.
Okay. Anyone else in the Justice Department, just again to circle back, you talked about the series of conversations you had with Mr. Miller, the PAYDAG. Anyone else in the Justice Department you talked with prior to Mr. Garland offering you the position of special counsel? You talked to the DAG, you talked to Lisa Monaco.
Well, yeah, so I flew to the United States from The Hague at some point in late October, and I met the Attorney General and I met Lisa Monaco. That was in late October of 22.
Okay. And anyone else in that meeting? Was Mr. Miller in that meeting?
So it wasn't a meeting, it was separate. I was at the DOJ, I met with Lisa Monaco, and then separately from that, I met with the Attorney General. I do recall the meeting with the Attorney General wasn't that long. Matt Clapper was present for that meeting, and I believe Marshall Miller was present for that meeting. With regards to Lisa Monaco, I cannot recall if Mr. Miller was there or not. He may have or he may not have been.
All right. Well, that's enough for this. Oh. These Republican questions are just aggravating, guys. I mean, what? They're just trying to push a narrative that they made up. It's completely just harebrained. And they're asking all kinds of just stupid questions. When did you meet this person? When did you talk to that person? When did this person show up? Who introduced you to this person? Where did you meet this one at? Oh, you said you talked to this one that time. Oh, okay. Well, did you review the files here? Did you review the files there? Oh, you just talked about it? You didn't actually get a digital? Oh, well, okay. What the hell, people? I mean, you're not going to try to take apart his evidence. You're not going to try to, I don't know, give an alternative view of the facts or the things he came up with or the things that are actually in the report. You're just going to talk all around it. You know, I think that a lot of people, they don't I mean, I know I certainly don't. I mean, I don't take the time with everything to sit down and watch all these hearings and do all this stuff, but I feel like if more people did this right here, what I'm doing, and actually listen to some of it, maybe not necessarily all of it, but at least a couple hours of it, they come to the same, a lot of them, surely to God, become the same conclusion I am, which is, these Republicans don't know what the hell they're talking about. I mean, they're wasting all this time asking all these other around the fact questions. It's like someone walked in and said, hey, I got a book here and it's got all the secrets about how we can fix like the best food in the world and how we can cure all kinds of diseases. And all they want to talk about is, well, where'd you get it at? Who did you talk to before you got it? Is that book binding? Is that quality paper, or is it like just standard paper? Who cares? It ain't important. What's important is what's in the book. Anyway. Okay, well, that was Mega Man 2. So, I guess next time, we'll just hit up Mega Man 3. And we'll listen to some more Jack Smith and, you know, see if the Republicans ever start asking any kind of questions that are actually interesting. And, yeah, we'll go from there. All right, Spartans. See you next time.